before Kelo came down, this was a backwater of the law. Virtually no one had ever heard of eminent domain, despite the fact that it was used throughout the country to take people's homes and businesses away from them, despite the fact that it had been used in the 1950s and the 1960s to completely devastate neighborhoods. It was still not commonly known, not written about in any but local newspapers or local television. There was virtually no legislative reform going on. When there was, it was a little bit of nibbling at the edges. I think in the 10 years preceding Kelo, there had maybe been 3 states that had done anything related to eminent domain legislatively. And then there were a few state court decisions, but not much, and a lot of the kind of deference that, of course, we then saw in the Kelo decision itself. There, furthermore, was absolutely no grassroots activism against eminent domain. People experienced eminent domain occurring, thought that they were alone in the world, and if they did not have the money to fight it, they would cave in. And that was pretty much what was going on up until the moment the decision came down. And then everything changed. There was a just overwhelming backlash against it. You heard about the opinion numbers, which were very much opposed, of course, in the 80s and 90s, and they're still there. But there was also tremendous change politically. And there were, just to give you the basic outlines, 40 states that changed their statutes, 11 that changed their state constitutions, 30 that narrowed the definition of public use, 25 changed their definitions of blight, 9 states changed the burden of proof, putting the burden of proof on the government for the very first time. And then 2 states just said you can't transfer condemned property to private parties at all. Now, I'm going to talk about some of the disagreements that Ilya and I have about the extent of the legislative reforms, but there are some states that had weak reforms, although very few actually, Roger, that I believe had cosmetic-only reforms. There were some states that had okay reforms, quite a number that had good reforms, and then some that had really good reforms. And the bottom line is 2/3 of the states, you are vastly better off now than you were just a few days before the decision came down. Now, we can't lose sight of what that accomplishment means. It does not mean that everyone in every state is protected. New York being the primary example. It was a terrible abuser before the decision. It did nothing about it, and it's still a terrible abuser. But everywhere else, the picture has changed, and that is a huge shift. Let me talk a little bit about why I'm more sanguine about the effects of political reform than Ilya is. And part of that is actually also the inclusion of the results of judicial decisions. So, for example, California, which I fully admit had pretty weak seeming reform in terms of its legislation, we secured a decision that made it stronger so that it actually is possible now to challenge a blight designation. Or I should say more possible, because people did sometimes successfully challenge them before, and there is now even stronger precedent for doing that. In addition, California, because of its budget crisis, just completely got rid of all redevelopment agencies, and that has certainly cut back very, very significantly on eminent domain abuse there. One state that turned out to be more of a problem than I think I initially thought, and for different reasons than Ilya thought, was Colorado. which had previously been a place that had not very much eminent domain abuse. And although their blight laws are actually not bad, in my opinion, they changed their procedures in a strange way that now makes it very difficult to challenge eminent domain. In particular, they are failing, I believe, unconstitutionally failing to give notice of your opportunity to challenge your blight designation, and this creates a problem for people who are unhappy about the use of eminent domain for private development or for any kind of development as a result of blight. But that is unconstitutional. It's been struck down in other places, and it will be struck down eventually there, at which point Colorado, I think, will turn out to be pretty good again. One other major issue that Ilya and I differ on is there are a number of states that did leave in place somewhat general criteria for areas that were blighted, but they required a property by property examination. The rule before used to be an area just could be designated as blighted, and you didn't really have to look at the actual properties. So for example, in Philadelphia, they designated some huge portion of the city to be blighted based on the fact that 10% of the properties lacked parking. You can't do that anymore in Pennsylvania, but the point being that it used to be that it was just almost a glance was enough. Requiring property by property, even when your definitions are vague and bad, requires a lot of work, and people, what we've been seeing is that when they have to go property by property, when they have to designate carefully, a lot more property doesn't get condemned, and you can't do the we're going to wipe out a neighborhood. Instead, there's a property here, a property there. Maybe it really would be better not to do this via eminent domain, because the reason that cities and developers want eminent domain is they want to just wipe out huge areas, usually. And when you are forced to go property by property, the game changes. And that has been, I think, something that makes a number of the states that Ilya rates low as actually better than he thought. And I'd include Iowa, North Carolina, West Virginia in that category. The other thing that has happened is that several of the states that had either no reform or really weak reform had great court decisions. That includes Ohio, the case that Roger mentioned when he was introducing me. Ohio both said economic development is not a public use in our state, and furthermore, blight means something better be really wrong with it. It can't be like, it can't just be any neighborhood, or you could imagine something nicer there, which is typically what cities have been using as their standard. Oh, we could imagine this neighborhood that's been there for 25 years is a brand new, really pretty neighborhood, and therefore it's blighted. Can't do that in Ohio anymore. Oklahoma also had a good decision. They had no legislative reform, but a really nice decision shortly after Kelo rejecting it. So putting some of these together, I think the picture is actually substantially, Missouri is another one. Missouri had weak reform, but it's had a couple of pretty important state high court decisions rejecting, based on its weak statute, actually rejecting a huge development project that it said violated the statute because it really was for economic development, and then starting to look at the evidence of blight, something that Missouri never did before the backlash occurred. So all of that put together, I think we are looking in general at a much better picture of what the states are doing than we were before. Now, let me talk a little bit about how we got there. Firstly, IJ resolved that we had to get there. We were so distraught by that decision that we just decided it was a loss and we were going to win anyway. And we therefore launched the Hands Off My Home campaign. We took the states, we divided them up amongst me, Scott, Stephen Anderson, who's there, and a couple other attorneys, and we started working with activists and legislatures in every single state. We provided testimony, we helped them draft things, we provided information. We worked extensively with national groups like the NAACP, particularly in Florida, in Pennsylvania, in Ohio, in Minnesota. They were indispensable to the reform efforts there. And that made a huge difference. We also worked with state-based reform groups like Jeremy Hopkins. So all of that changed the picture of what happened. We also did and continue to do follow-up litigation. And we released reports, including, for example, Victimizing the Vulnerable, which statistically proved that eminent domain does, in fact, get used, as we had been saying, primarily in areas that are poorer, less educated, and more minority than similar areas in their city. But eminent domain is used against the powerless. And so we were able then to show that statistically. I also want to talk for a moment about grassroots activism, because that is something that also has completely changed. Since Kelo came down, we have worked with activists in 62 communities to defeat the use of eminent domain against 16,000 homes and businesses. And many of these were for economic development, but a lot of them were not. Because the fact is that now people know that this is an abusive system and they are willing to fight it. And that kind of grassroots resistance and working with communities to do that has been remarkably successful, even in places like New York and New Jersey, which are very bad judicially, usually, about eminent domain. So what then is next? What do we need to do to further eradicate the abuse? Well, certainly the states that have not improved their laws need to do so, New York being the chief among those. I think legal challenges will continue to be important to reinforce good legislative changes, and actually some states are still making continued improvements to their statutes. North Carolina, I think, it keeps trying, and eventually it's going to get there and make its law a better law. Activism is going to continue to be really, really important, and important not just for economic development takings, but for, like they were talking about in the prior panel, totally ridiculous, unjust, unnecessary takings for roads, for universities, and for anything which is pretty much everything, where eminent domain does not have to be used. And in fact, private purchase, or if it's actually a government use, not that frequent, government purchase could be used. But activism is going to be a critical part of preventing eminent domain abuse. And we will be working on all of those fronts, legislative, activism, and of course, court cases in the coming years. Thank you.